Okay, so I think we can all agree that Stearns' defence team have lost the plot. Honestly, as I was about to start on this video, I thought I'll just go in and have a look and see if there's any more documents. And oh my gosh, they have just filed another pile of documents. You wouldn't believe how many documents have been filed. So this particular lot of filing that I was going to talk about is so many documents, it's ridiculous. And I'm going to try and go through them all, but at the end of the day, it's just a complete utter joke. And I'm hoping that the judge turns around and actually has words with this defence attorney and says, you're making the whole case look like a circus. And basically puts her in her place. It sounds like having just been elected to the office of district defence, or whatever it's called. She's trying to prove herself. I would say she is working her team really badly, like pushing them to the limits, because the amount of hours that are going into these ridiculous motions must be insane. And we know that these aren't coming directly from her. This would be written by staff on her watch, basically. So she's basically pushing her staff to the max. I would be surprised if any of them are getting much downtime. And given the information that I discovered about her yesterday, I think this is just... I'm just gobsmacked. I really am. So I did a video yesterday where I actually spoke about the defence, the head of the defence, and information that I found about her. So if you haven't seen that, it's probably worth going and having a looking at. But in this video, I'm just going to read through some of the motions. Not all of them, because I think it's going to take hours and hours. So I think I'm just going to start and read through as many as I can cover in an hour and a half. And then maybe move on to some more tomorrow. I will, as with the other motions that I've read, put all these into my Patreon, so that anyone who wants to read them can read them. If you are not familiar with my Patreon, it's a free Patreon. There's no charge to become a member. All these documents will be available for free for all members. I do have a $1 and a $2 paid tier for anyone who wishes to just give me that little bit of extra support. But in terms of the majority of documents that I'm going to be putting on my Patreon, they will mostly be available for free for everyone. So let's jump in and have a look at some of these motions. So it seems that this woman is afraid that the jury are going to see just how much of a monster Stearns is, and that they are going to judge him accordingly. Well, isn't that what all this is all about? So, defendant's proposed implicit bias jury instruction. So, now she's telling the judge how to instruct the jury. Do not decide the case based on implicit biases. As we discussed in jury selection, everyone, including me, has feelings, assumptions, perceptions, fears, and stereotypes, that is, implicit biases, that we may not be aware of. These hidden thoughts can impact what we see and hear, how we remember what we see and hear, and how we make important decisions. Because you are making very important decisions in this case, I strongly encourage you to evaluate the evidence carefully and to resist jumping to conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. The law demands that you return a just verdict based solely on the evidence. Your individual evaluations of that evidence, your reason and common sense, and these instructions. Our system of justice is counting on you to render a fair decision based on the evidence, not on biases. Well, I really hope that the judge serves her ass for this, because basically she is telling the judge how to do his job right here. She's saying, here, let me write your instructions for the jury for you. That is so presumptuous. I can imagine that this woman goes around treading on toes left, right and centre. So that is the first of her motions that's been filed. Now, I'd really like to know what the purpose is behind all these motions that are being filed. Is she trying to influence public opinion? Is she trying to influence the judge? Is she just trying to crack the whip and seem like some super qualified public defender? Because this is just all a load of tosh. So now we have Stephen Stern's objections to the use of follow the law questions to rehabilitate or qualify jurors. Well, okay. Through counsel, Mr. Stearns objects to the use of any follow the law type questions to rehabilitate or qualify biased and death verdict prone jurors, and he moves for a court order prohibiting use of these questions. Use of this type of questioning to qualify or rehabilitate jurors has no place in capital jury selection, as made clear by Morgan v. Illinois. The defendant raises this objection under these authorities and pursuant to his rights to due process and an impartial jury, and his protections against cruel and unusual punishment. So he wants to... I really don't get what's going on here. I mean, the ultimate goal here is to avoid the death penalty, clearly. But it seems like they're just throwing whatever they can at the wall to see what'll stick, basically. Mr. Stearns states, 1. The right to have a jury make the ultimate determination of guilt has an impressive pedigree and is the most important element in an accused's right to a jury trial. Trial courts must therefore ensure that the jury is impartial and indifferent. Well, yeah, that's part of the process. So there's nothing new in that. Oh, here I go with the bad pronunciations again. I apologise. Voir dire protects the defendant's right to an impartial jury by providing him or her with the ability to discover juror biases and prejudice. Yeah. It is one of the most important parts of a trial to litigants. Voir dire must therefore be conducted in a way permitting counsel to determine whether a juror has beliefs or attitudes causing bias against the defendant that would deprive him or her of the right to a fair trial by an impartial jury. Well, I don't get it. Isn't that just part of the process? Sounds like they're basing a lot on this Morgan versus Illinois. Seems to pop up everywhere. So, in Morgan versus Illinois, the United States Supreme Court held that not only is the capital defendant entitled to an impartial jury, but such a defendant is also entitled to have the court strike for cause any juror who will automatically vote for death if the defendant is convicted. The court reversed the death sentence and explained a juror who will automatically vote for the death penalty in the case before him or her will fail in good faith to consider the evidence of aggravating and mitigating circumstances as the instructions require him to do. Indeed, because such a juror has already formed an opinion on the merits, the presence or absence of either aggravating or mitigating circumstances is entirely irrelevant to such a juror. Therefore, based on the requirement of impartiality embodied in the Due Process Clause of the 14th Amendment, a capital defendant may challenge for cause any prospective juror who maintains such views. Even if one such juror is impanelled and the death sentence is imposed, the state is disentitled to execute the sentence. So, on one hand, I get what they're saying in terms of in jury selection, if they ask a juror, if this person is convicted, will you automatically choose the death sentence? Then yes, there is a bias there, and then the juror probably should be struck. But to turn around and say after the fact that they believe that a juror was going to go for the death sentence, and that should then wipe out the death sentence, well, you know, if the lawyers are doing their job properly during jury selection, that should not occur. So basically, it sounds like what she's basically trying to do here is not only ensure that when the jury selection occurs that there are no jurors selected that are automatically going to vote for the death penalty, which is a fair call, but she's also trying to add a little clause in here that if the jury then decides for the death penalty, that she can turn around and say, oh, well, this juror was biased and they were always going to vote for the death penalty after the fact. Which to me sounds insane. She's basically trying to set up an argument that doesn't, at this point in time, exist. Any juror to whom mitigating factors are likewise irrelevant should be disqualified for cause, for that juror has formed an opinion concerning the merits of the case without basis in the evidence developed at trial. Well, yes and no. Because at the end of the day, the jurors decide guilty. This is my understanding of death penalty trials. The jurors decide if the person is guilty or not guilty. And then you hear mitigating factors, at which point the jury then make the second decision as to whether or not a death penalty sentence should be incurred. So I don't think if a juror decides that the mitigating factors are inadequate, how can you know that they're how can you know that they're not saying that they're inadequate as opposed to irrelevant? She's basically trying to say that the jurors have to consider mitigating circumstances and put a whole heap of weight on that. I really don't like this lawyer at all. As Justice Scalia explained, the Morgan ruling means a state is constitutionally compelled to exclude jurors who would, on facts establishing the particular aggravated murder, invariably impose death. The Morgan versus Illinois rule exists because it's unconstitutional to have a sentencer who cannot or will not in a particular case give meaningful effect to mitigation, but who would instead always return a death verdict if the allegations were proven. Such persons are not qualified to serve on a capital jury, as the Supreme Court stated in Eddings versus Oklahoma. Different state. Just as the state may not by statute preclude the sentencer from considering any mitigating factor, neither may the sentencer refuse to consider as a matter of law any relevant mitigating evidence. Emphasis added. 4 years later, the Supreme Court reiterated this rule. There is no disputing that this court's decision in Eddings requires that in capital cases the sentencer not be precluded from considering as a mitigating factor any aspect of a defendant's character or record and any of the circumstances of the offence that the defendant proffers as a basis for a sentence less than death. Equally clear is the corollary rule that the sentencer may not refuse to consider or be precluded from considering any relevant mitigating evidence. These rules are now well established and the state does not question them. Well, that makes sense. I mean, they're basically saying that the jurors have to consider mitigating factors. Full stop, end of story. But I think what she's aiming for here is to essentially say that if there's any mitigating factors, then they shouldn't vote for the death penalty. I think she is trying to stifle the jury a little bit here. And I think it's a very, very subjective thing. And it sounds like, to me, like the argument here is going to be that the jury shouldn't put forward a death sentence because of certain mitigating circumstances. I mean, basically she's just stating simple facts of law here. So it makes me question the motivation. And to me, the motivation is that she is going to try and put extra weight on mitigating factors and claim that if the jury don't accept these mitigating factors, then they are biased, and that they were going to put forward a death sentence regardless of mitigating factors. Let's keep reading and see if this is what she is actually getting at. The United States Supreme Court in Penry versus Lino further stated, Eddings makes clear that it is not enough simply to allow the defendant to present mitigating evidence to the sentencer. The sentencer must also be able to consider and give effect to that evidence in imposing sentence. Only then can we be sure that the sentencer has treated the defendant as a uniquely individual human being. Internal citations omitted. The Supreme Court has never wavered from these principles, as Justice Stevens, writing for the majority in Abdul Kabir versus Quarterman, explained. Justice O'Connor's opinion for the court in Penry, I endorsed the views she had expressed in Franklin and unquestionably governs the facts of this case. The same principles originally set forth in earlier cases such as Lockett and Eddings have been articulated explicitly by our later cases, which explained that the jury must be permitted to consider fully such mitigating evidence and that such consideration would be meaningless unless the jury not only had such evidence available to it, but also was permitted to give that evidence meaningful mitigating effect in imposing the ultimate sentence. You know what? Now, if you listen to one of my videos earlier where I was reading through other motions put forward by the defence, one of their motions was that they wanted to be able to put forward mitigating circumstances without providing evidence, which I read that as saying they wanted to use his supposed acquired brain injury as evidence. But now, in this motion, she's saying that mitigating evidence must be considered fully. In other words, mitigating circumstances are meaningless unless there is evidence. This motion contradicts the other motion that they put forward before, basically saying that they should be able to cite mitigating circumstances without providing the evidence. I'm starting to think that this woman has basically just said to all these people in her office, right, I want you to come up with all these precedents with relation to death penalty cases, and we're going to put them forward as motions. I don't think she's even bothered to take the time to read through them all herself, because this is completely contradictory to that previous motion. I really hope that this judge is someone with a firm hand and that he makes some sort of ruling and sits this silly woman on her ass, because she's just turning this whole process into a joke. The court may excuse a juror if his or her views in opposition to the death penalty would prevent or substantially impair the performance of the juror's duties. However, it is error to excuse a juror for cause merely because he or she would be more serious about the penalty or have a general reluctance to impose it. Well, yeah. You know what? I should create a new playlist and call it the I Can't Sleep playlist, so that when anyone is having trouble getting to sleep and they want to listen to something that is so inane, they can just listen to me reading through these documents, because, like, this is just ridiculous. Utterly, utterly ridiculous. So at the top of the page here we have Mr. Stearns objects to the use of the magic question in any form to qualify or rehabilitate jurors. 7. In performing this careful evaluation, courts, particularly in cases where the state seeks the death penalty, may not resort to follow-the-law type questions or generic questions asking for jurors' bottom-line conclusions about bias or absence thereof to either qualify or rehabilitate biased jurors. As to general questions of fairness and impartiality, such jurors could in all truth and candour respond affirmatively, personally confident that such dogmatic views are fair and impartial, while leaving the specific concern unprobed. More importantly, however, the belief that death should be imposed ipso facto upon conviction of a capital offence reflects directly on that individual's inability to follow the law. Any juror who would impose death regardless of the facts and circumstances of conviction cannot follow the dictates of law. It may be that a juror could in good conscience swear to uphold the law and yet be unaware that maintaining such dogmatic beliefs about the death penalty would prevent him or her from doing so. Oh my gosh, are they just like copying out of a textbook or something? It's like she's just pulled up a textbook for law students that is actually explaining how these cases work and is trying to put forward basic text from textbooks as motions. Because I'm pretty certain that when they are going through jury selection, they are going to explain these things to the jurors. They are going to select the jurors from people who understand that giving a conviction of guilty doesn't mean that they are obliged to give a death sentence, but that if there are not enough mitigating circumstances that they probably should give a death sentence. I really can't see the point of these documents. Honestly, why not just hand the judge a textbook from law school and say, here, read this. This is my motion for this case. Okay, point 8. Voir dire is not a stark little exercise designed to qualify jurors quickly. It is one of the most important aspects of trial. Given the important rights at stake, retention of a potentially biased juror cannot be made by avoiding any real inquiry into the possible bias, revealing the bias's source, depth, and extent. Can someone tell me, this just sounds like common sense. This sounds like what I would expect to happen anyway during jury selection. The only thing I can see in this document is that she is trying to set things up to create a jury that will be biased towards not giving a death penalty if there are any mitigating circumstances. Other than that, seems like she's just throwing out all these precedents that are really just... This reads like a university law paper. Someone who has just been doing a unit studying death penalty cases and is explaining how they work. I'm pretty certain that the judge knows what he's doing and doesn't need this silly woman telling him how to do his job. Okay, so 9. Questions calling for conclusory answers regarding bias, actual bias, make the juror, not the judge, the final arbiter of assessing whether their state of mind renders them unfit for jury service, and regardless, jurors will not always readily volunteer they are biased, or will fail to recognise they are. So now we need a judge who is a mind reader. Or are we going to put all the jurors through a lie detector test? How about that? Let's make all the jurors sit through an 8-hour lie detector test to see if they're telling the truth. What the... You're always going to encounter this. You may have a juror who is biased and who claims that they are not biased. Unless you're a mind reader, you're not going to know that. Ridiculous. Thus, the Supreme Court recognises the magic question, can you follow the law, has no place in voir dire in capital cases. Well, of course it is. Don't you want a juror who is going to follow the law? A juror who's going to follow the instructions given to them by the judge? Follow the law questions earn the pejorative the magic question for good reason. One of the myths arising from the folklore surrounding jury selection is that a juror who has made answers which would otherwise disqualify him by reason of bias or prejudice may be rehabilitated by being asked whether he can put aside his personal knowledge, his views, or his sentiments and opinions he has already and decide the case instead based solely on the evidence presented in court and the court's instructions. This has come to be referred to in the vernacular as the magic question. Montgomery versus Commonwealth. There is no magic in the magic question because answers to such questions may suggest overt acquiescence in the trial court's efforts to elicit a commitment to neutrality and may simply result from the prospective juror telling the court only what it wants to hear. Seriously, or it could be that you just have a juror who is educated enough to actually be capable of listening to the evidence that is given to them in court and making an educated decision. That is such a ridiculous argument. I can sort of see where she's coming from, but at the same time, it's basically inferring the jurors are all idiots, incapable of independent thought, incapable of putting aside their biases and actually making an educated decision. And really, at the end of the day, we're talking about an age-old practice here. So, what does she want to do? Would she like to change it so that the defence chooses all the jurors and they put them through a rigorous polygraph test first before they select them? Okay, moving on. Concluding that a prospective juror is qualified to sit simply because he says he will be fair ignores the common sense, psychological, and legal reality of the situation. Not so remarkably, jurors confronted with this question from the bench almost inevitably say yes. Probably because a majority of those jurors are actually intelligent people capable of independent thought and capable of putting aside biases and judging based on the evidence put before them. The whole point of having a jury of 12 is that it will weed out any biases. If you have one juror in there who does have a bias, that'll be weeded out in the whole process. When the jury is deliberating, it will become pretty clear pretty quickly. Okay, point 11. These types of follow the law questions are grounds for reversal of death sentences when unqualified jurors end up on the jury, as explained eloquently by the Louisiana Supreme Court as it reversed a death sentence. Oh my gosh. So this woman who's looking at basically things from all over the country, and like I said, it does sound like someone's writing an essay for their university degree. The trial judge's limitation of the defence's questioning to whether the jurors would accept the law as given has never been favoured in our law. Rather, this court has rejected the contention that unjustified restrictions on voir dire can be cured by a response on the part of a prospective juror that he will follow the law as given to him by the judge when the juror is unaware of the complexity of the law and where that law involves such a basic right of the defendant. Counsel must be permitted to informally question the juror of his own experiences and attitudes that may influence his ability to follow the law. A juror's response to less imposing questions may well reveal attitudes and biases not disclosed by superficially correct answers. Well, isn't that what happens in the jury selection process? Doesn't both sides question prospective jurors? And then they have so many vetoes that each side is allowed. So I really don't see the point of this argument at all. Unless, of course, when they talk about prospective jurors being unaware of the complexity of the law, they're now proposing that juries should be made up of trained lawyers. Like, hello? You know, if you've got a decent judge, then they talk the jury through the entire process. They explain the process to the jury along the way. They explain before the trial starts. They explain when the jury is about to go and make deliberations. Basically, it sounds like this woman is trying to tell the judge how to do his job. Okay, so now the next motion that we have. Motion to prohibit questioning of potential jurors as to their willingness to render a verdict for the death penalty. Okay. Stephen Stearns, through counsel, moves this court to prohibit questioning of potential jurors as to their willingness to render a verdict for the death penalty, and in support would show: 1. Mr. Stearns is charged with first-degree murder and the state of Florida is seeking the death penalty. It is anticipated that the state will question jurors as to their willingness to render a verdict for the death penalty. This line of questioning is improper since it does not lead to proper challenges for cause or the appropriate race-neutral use of preemptory challenges. Sorry. I would have thought it would be important when you are selecting jurors to know if those jurors are willing to render a verdict for the death penalty. Because otherwise you're just wasting time on a trial. If a juror has such a strong bias against the death penalty, then you don't want them sitting at trial. You have the potential for a hung jury, for starters. And you also have the potential for misjustice. If the person is worthy of a death penalty, then having jurors who are anti-death penalty jurors is basically screwing with justice. Florida law provides that a juror is never required to recommend a sentence of death, irrespective of their findings on weighing aggravating and mitigating circumstances. Regardless of your findings in this respect, however, you are neither compelled nor required to recommend a sentence of death. Florida Standard Jury Instructions. Section 913 provides an exclusion for jury service only for those who hold beliefs which would preclude them from finding a defendant guilty of an offence punishable by death. All the law requires is that the juror actually considers the evidence and the law. I think this is a gross misinterpretation, because if you are going to select jurors for a death penalty case, then obviously the jurors need to know that they will be required to make that decision if they go with a guilty charge, right? So I think, I wonder if she's got like interns working for her who aren't even fully qualified lawyers yet and are just grasping at straws here and going, well, let's reinterpret this and see if we can convince the judge that this is what it actually means. Okay, so point 4. Asking a potential juror whether he or she would in fact vote for a sentence of death is impermissibly asking a juror to commit to a verdict. Right. Holding that prosecutors' question in voir dire as to whether the juror would convict if every element is proven was improper. It is not relevant to a cause challenge because the law never requires the juror to vote for sentence of death. In order to constitute an appropriate challenge for cause, the potential juror's options must prevent or substantially impair the performance of their duty in accordance with the instructions and oath. The duty as set forth in the jury instructions is to consider the facts and the law. The duty is never to impose the death penalty. But it's two separate things. They have to consider the evidence brought to them and the law, and they have to make a verdict of guilty or not guilty. And then I believe there is the sentencing phase when they are presented with the arguments, the mitigating circumstances, etc., which is then when they have to vote for or against the death penalty. Is that not how it works? I'm just finding these motions to be really confusing. Seems to me that Basically, they are trying to convince the judge that the jury should not be allowed to make a verdict, a decision as to whether or not Stearns should actually receive the death penalty. Sounds like they're saying the jury can make the decision whether he's guilty, but it's not up to them to decide the death penalty. Well, we don't have death penalty in Australia, so this is really confusing for me, because I thought I was getting my head around this. Please leave comments below. Let me know if you've followed other cases and more familiar with this. Let me know what's going on here. Okay, point 5. Exercising preemptory strikes against jurors who are opposed to the death penalty denies Mr. Stearns his right to a jury comprised of a fair cross-section of the community, including those who follow religious teachings opposed to the death penalty, and many people of colour who are opposed to the death penalty. Aha, I'm starting to figure it out now. It's my understanding that lawyers have investigators who actually investigate their jurors. So there's a good chance that when they have their list of jurors, that they will do an investigation and find out if they've got any jurors who are opposed to the death penalty. And by preventing the prosecution from asking jurors, are you opposed to the death penalty? They're hoping that they can get one or two of these jurors in onto the jury. So basically what they're trying to do here is they're trying to weigh the jury in Stearns' favour. They're hoping that they can basically preempt all this, do an investigation, figure out which jurors are not likely to be in favour of a death penalty, and get those on their jury. Questions concerning a juror's willingness to impose a sentence of death predisposes the juror to believe that the death penalty is the issue, not the defendant's guilt or innocence. It also predisposes the juror to believe that death is, in fact, the appropriate penalty. Jurors should not be asked whether they can follow the law and impose a sentence of death. Although this question on its face inquires into a juror's capacity to return a death sentence, jurors are likely to infer that a death verdict is required by the law, at least under some as yet unspecified circumstances. So basically what they're trying to say here is that they believe the judge is too much of a half-wit to explain to the jurors that there is a separation between making a guilty verdict and actually saying that he deserves the death penalty, because that is what exists. And surely this is something that would be clearly explained to the jurors right through the process. I'm pretty certain they're not going to launch into a death penalty case without making it clear to the jurors that their first task is to decide whether or not he is guilty, and that is irrespective of death penalty or not, and that the decision regarding a death penalty only will occur after a guilty verdict has been made. This motion basically reads as, this lawyer thinks the judge is a half-wit. Okay, where were we? In the modern machinery of death, capital punishment. Yes, see, it reads like someone writing a university assignment. It's got C. Bloom, Lessons from the Capital Jury Project, Does that not sound like a textbook? In The Modern Machinery of Death, Capital Punishment and the American Future, 2001, as stated by one commentator, it gets the jury to think, oh, I get it, they're asking me if I can kill this guy. Yeah, I'll do that if that's what I'm supposed to do. ID, or put it another way. Now they're not even quoting precedent. Instead, they're quoting somebody's opinion out of a textbook. Oh my gosh. Now, as I look at this, I sit here and I desperately hope that when it comes to finances and the defence team asking the judge for approval of more money for their costs, that the judge turns around and says, in terms of staffing, you've overspent and this is how much you're getting. You're going to get half back now of what you are asking, because this is such a waste of money. I don't know if this is some apprentice, like I've said, someone who is still at university and she's trying to, I don't know, maybe her twin boys are at university and she's got them working on it or something. I don't know, but this is just pathetic. Okay, let's push on. 7. Because this is a capital case where death is a possible penalty, heightened standards of due process apply. Well, that makes sense. The court, in reviewing death sentences, the court has demanded even greater certainty that the jury's conclusions rested on proper grounds. So now they're just going to quote a whole heap of titles and quotes. That's all this is. It's a bunch of quotes here. Where a defendant's life is at stake, the court has been particularly sensitive to ensure that every safeguard is observed. Well, I mean, that's a given, isn't it? Okay, so let's read the last part. Okay, so I've just realised these are all signed by the Assistant Public Defender. So, sounds like this Melissa Vickers isn't even putting any of the work in herself. Wherefore, the defendant requests this court to prohibit questioning as to a juror's willingness to impose the death penalty and prohibit excusals for an unwillingness to do so, as long as the juror commits to considering the aggravating and mitigating circumstances in the determination of a penalty recommendation. So basically, she wants to prevent any jurors from being excluded if they are anti-death penalty jurors. Whereas in most cases, that is standard practice, where if a juror says that they would be unwilling to pass a death penalty verdict, then that juror would be excused. So basically she's trying to weigh the jury in Stearns' favour, which she can cite all this crap all she likes, but to me it actually sounds like it is a perversion of justice. Let me know your thoughts. Okay, I think I'll make this the last motion for this video, and then I'll come back in another video and do some more of these. So, and as we might have expected, motion to prohibit death as a possible penalty. Honestly, she's trying this from any angle she can. I mean, why not just put a big sign out in front of the courthouse, Stearns is guilty? Because these are such desperate measures that she must think that it is a definite possibility. So let's go through this. The defendant, through counsel, moves this court to enter an order excluding death as a possible penalty because selecting a jury based upon their opinions about the death penalty will violate Stephen Stearns' right to a jury and a due process of law. Oh my gosh. I'm going to go bash my head against a wall right now, honestly. I would like to see, having seen that there is now a whole new slew of motions today, which I haven't even looked at, I think there actually needs to be a petition to remove this person as a public defender and have a more capable public defender put in her place. I would love to know if legally that is possible through change.org to start a petition to have this Melissa Vickers removed as public defender, because she's just a joke. It is widely recognised that the process of selecting a jury in a case where the state is seeking the death penalty has an impact on diversity of the jury and juror attitudes. Jurors are excused either by cause challenge or preemptory challenge because of their opinions about the death penalty. And so they should be. Like I said with the previous motion. A. Stephen Stearns has a right to an impartial and fair cross-section of the community in his veneer. Under both the Florida and US constitutions, Mr. Stearns has a right to a trial by a jury drawn from a fair cross-section of the community. The presence of a fair cross-section of the community on veneers panels from which petite juries are drawn is essential to the fulfilment of the Sixth Amendment's guarantee of an impartial jury trial in criminal prosecutions. And we're back to citing just everything we can lay our hands on. When any large and identifiable segment of the community is excluded from jury service, the effect is to remove from the jury room qualities of human nature and varieties of human experience, the range of which is unknown and perhaps unknowable. It is not necessary to assume that the excluded group will consistently vote as a class in order to conclude, as we do, that its exclusion deprives the jury of a perspective on human events that may have unsuspected importance in any case that may be presented. Further, as to individual biases, it is appropriate that the veneer reflect a broad range. The counterbalancing of various biases is critical to the accurate application of the common sense of the community to the facts of any given case. Okay, yes, but if you are going to choose jurors who are dead set against the death penalty, then that is not fair. That is not justice. You can still have quite a large range, or a large representation of the community and still exclude those individuals who would basically vote based on their beliefs rather than based on the fact of law. Because that's what she's trying to say. She wants to be able to include people who are open about not believing in the death penalty, essentially. But she wants the death penalty off the table because it wouldn't allow for a range of representation of the community, which I think is utter BS. Further, as to individual biases, it is appropriate that veneer reflect a broad range. The counterbalancing of various biases is critical to the acute application of the common sense of the community to the facts of any given case. Right, sure. You will still get a broad range. If you take out those extremists from either side, because you're wanting to take out extremists from both sides. The extremists who are going to be dead set, all for the death penalty, can't change their mind. You don't want them. You also don't want the extremists who are dead set, no, never should be a death penalty. But you could still get a broad range of members of the community without those people. It is fundamental to the constitutional right of a trial that the defendant be provided an impartial jury. Excluding or excusing potential jurors based on their opposition to the death penalty will deprive Mr. Stearns of a veneer composed of a cross-section of the community, a veneer with various perspectives on human events and a veneer with a broad range of biases. No. I don't believe that is the case. Like I said, you are weeding out the extremists who are not going to allow for a fair verdict. B. Death qualifying. A jury prevents a representative cross-section of the community from serving on Mr. Stearns' jury. Research has established that a juror selected because he or she does not oppose the death penalty is more likely to be white. Robert L. Young, guilty until proven innocent, conviction, orientation, racial attitudes, blah blah blah. So now they're citing, I would imagine, a precedent to do with having a white jury on a case against a black man. Would I be correct? Or African Americans? Sorry, I'm Australian. I don't mean to be offensive. I don't know the politically correct terms to use. I would imagine that in normal circumstances, they wouldn't be overly fussed about whether or not they had only white people on a jury for a white man who is accused of these crimes. This is a ridiculous argument. African Americans as a class may be disproportionately excluded from jury service by virtue of the group's disproportionate view of the inappropriateness of capital punishment. Moreover, researchers categorise jurors in capital cases as demographically unique, in that they tend to be both white and male. Okay, well, hey, here's a proposition. Can we have all African American females instead? That'll fix it. Only joking. The disproportionate exclusion of blacks appears to have a significant impact on the outcome of capital cases. Seriously? I'm pretty certain that if you were to look into that, that would be looking at a case of capital cases against black men, not against white men like Stearns. In all statistical models, black jurors are significantly more likely to oppose the death penalty than are white jurors. Age is also a factor. Older jurors continue to be more sure of the death penalty's appropriateness as compared to their younger counterparts. Okay. Death qualification also impacts the age and gender of jurors. Men of all ages, with the exception of the youngest men, those approximately 20 to 30 years old, were more likely to choose the death penalty than were women. Approximately 49.1% and 65.1% of men and women respectively chose the death penalty. Younger and older men were less likely to choose the death penalty than were men approximately 40 to 60 years old. Young women in the age range of early 20s to late 30s were more likely to sentence the defendants to death than were older women. As age increased after 40 years, the probability of a woman choosing the death penalty gradually decreased. It would be a clear violation of the right to a jury representative of the community to exclude women. Yet the accepted process of death qualifying does this very thing. Death qualification also impacts the presumption of innocence. Numerous studies support Justice Stevens' observation. Preoccupation with death qualifications creates an atmosphere in which jurors are likely to assume that their primary task is to determine the penalty for a presumptively guilty defendant. Justice John Paul Stevens address to the American Bar Association at an awards dinner, mind you. Oh my gosh. So they've thrown away looking at actual precedents now, and they're just basically scrabbling. At the end of the day, the whole point of this whole voir dire, sorry, I can't pronounce it, but the whole point of the jury selection process is that you take these things into account. Both sides are allowed to say however many jurors they're allowed to exclude those jurors. So the whole jury selection process is designed to get around these problems. So basically trying to take the death penalty off the table because they think that there's a problem with the jury selection process is basically attacking the entire court system throughout the United States. I don't know how many times I can say this, but this is just a joke. Research shows hearing all those questions about the death penalty and seeing the dismissal from service of other potential jurors who express grave doubts seems to send the message that the judge and the lawyers, the authority figures in the courtroom, think this defendant is guilty and deserves death. No, it doesn't. Unless the judge is a complete quack and doesn't explain it to the jurors, then the jurors should at least understand the process and what is going on. He emphasises that this is especially problematic because jury selection occurs at the very beginning of the process and thus creates a powerful first impression. Does anyone else think this is just a complete joke? This is just a farce. This woman is wasting money putting together ridiculous motions that the judge is going to throw out. They don't even make sense. The judge is going to look at these motions and just say, go away, and if you really want to put in a motion to have the death penalty removed, come back with a logical argument. Okay. When jurors are repeatedly asked whether they can follow the law and impose the death penalty, they begin to believe that the law actually requires them to reach death verdicts. If they are half-wits, death qualification becomes a kind of obedience drill, in which jurors feel they are voluntarily relinquishing the power to deviate from the outcome the law seems to favour. The personal characteristics of many death-qualified jurors render them especially receptive to arguments that they must follow the implicit promise made to the court. The most recent statistics show less than half of this country's population favour the death penalty. Death penalty loses majority support for the first time in 45 years. New York Times. Okay. And they questioned how many people. You can't... I can't believe the arguments that are being made here. These are clearly... They must have come from a journal of lawyers who oppose the death penalty, basically. It is an argument that is put forward by these people who want to see the death penalty permanently removed, and it is not necessarily a logical argument. This could mean that less than half of eligible voters are actually eligible to sit on a jury if the state makes the unilateral decision to seek the death penalty, Almost 50 years ago, Justice Stewart noted the impact on a defendant's right to a jury from a cross-section of the community when he commented, "Yet in a nation less than half of whose people believe in the death penalty, a jury composed exclusively of such people cannot speak for the community." Culled of all who harbour doubts about the wisdom of capital punishment, of all who would be reluctant to pronounce the extreme penalty, such a jury can speak only for a distinct and dwindling minority. Death qualification eliminates any juror who, for religious or moral reasons, is opposed to the death penalty. These are jurors that Mr. Stearns has a right to have in his veneer. These are jurors who comprise an impartial and fair cross-section of our community. They're not impartial if they are against the death penalty, because that means that they are not going to vote for the death penalty no matter what. You need jurors who are prepared to do so. Like I said, you need jurors who are not from either extreme, but those people who are prepared to consider the death penalty. This is a really poor argument. And coming from the perspective of an Australian, we don't have the death penalty in Australia. And until this case came along, I would have said, no, I don't believe in the death penalty. But I can assure you right now, from all the information I've learned about this case, from learning what he did to her, from learning what she went through for the 7 or 8 years before she died, I am in favour of the death penalty in this case. Would I be an impartial juror? I'd like to think I would, because I am educated enough to make decisions based on evidence. Right now, the evidence that I see is that this guy is a scumbag and he deserves the death penalty. Am I biased? Maybe. But I don't think I am. I think what we've seen of this case shows us that this guy does deserve the death penalty. And coming from an Australian, from someone who lives in a country that does not impose a death penalty, that's pretty powerful stuff. I should also mention, I don't fall into the category of people who they listed here as the sort of people that would favour a death penalty. According to their statistics, I shouldn't favour the death penalty. Okay, so now we go to, the state does not have a legitimate interest in excluding jurors based upon their opinions about the death penalty. In Lockhart versus McCree, the court held that death qualifying a jury did not violate the cross-section requirement of the Constitution when the state has a legitimate interest in obtaining a jury that can properly and impartially apply the law to the facts of the case at both the guilt and sentencing phases of a capital trial. McCree did not argue that the process of death qualification was instituted as a means for the state to arbitrarily skew the composition of the jury. Mr. Stearns does make this argument. Sorry. I just had to do it. I had to snort there. I don't get it. It strains credulity to believe the state acts in good faith when it seeks to death qualify the jury in this case. The defendant is aware the court in Buchanan versus Kentucky held death qualification appropriate in a joint trial, even though Buchanan was not subject to the death penalty. However, the court specifically found the government had a legitimate interest in one trial. This case can also be distinguished from Smith versus State. In Smith, the court held the trial court did not err in failing to inquire into the state's good faith basis to proceed with death qualification. At the time Smith was decided, the state only had to prove one aggravating circumstance to support a death sentence. There was no requirement that the state also prove aggravating circumstances sufficient to impose death and aggravating circumstances that outweigh mitigation. Okay, well that's a different case, isn't it? I don't know, I'm speechless. I just think this is a joke. The state should be precluded from seeking a sentence of death when there is no good faith basis to believe that a jury will unanimously find beyond a reasonable doubt that aggravating facts exist, that sufficient aggravating factors exist for the imposition of the death penalty, that the aggravating factors outweigh the mitigating circumstances, and that a jury will find that death is the appropriate verdict. The only possible motive for pursuing the death penalty in this case can be to skew the composition of the jury or coerce a plea. Both would be constitutionally impermissible. Under both the Florida and US constitutions, Mr. Stearns has a right to a trial by an impartial jury drawn from a fair cross-section of the community. This court has the duty and the authority to prevent the government from violating important constitutional rights. Death qualifying a jury denies Mr. Stearns his right to due process and a fair trial. Wherefore, the defendant requests his honourable court to grant the foregoing motion. So I'm going to wrap this up using an image of Maddie because I just don't want to look at any of that stuff anymore. It's just doing my head in. I think the whole point of jury selection is so that both sides have a say in the jury that is being selected, to make sure that it is a fair representation of the community. These are arguments that are probably come from anti-death penalty people. Basically, very few of these arguments seem to have precedent. They are quoting speeches. They are quoting textbooks. They're not quoting a lot of precedent here. And note that last motion was also by the assistant, not by the actual public defender. So it seems like she's basically working this assistant to the bone, or her and all her other staff. I will continue reading these motions in another video if you wish me to. The ones that I've read, I will put them straight into Patreon tonight, so that if you want to read through them yourselves, go for it. Like I said, my Patreon is free. Just have to sign up, free membership, and then all the documents in there are free. Like I said, there is a $1 tier and a $2 tier if you are interested in supporting my channel, but by no means is that something that I expect of people. Well, I don't know about you, but my brain is just fried from reading through all this and trying to figure out what's going on. But I think at the base of all this is that Stearns' lawyer is doing everything they can to get the death penalty off the table, which to me says that they believe he is guilty, as they realise that he is going to be found guilty, and they just want to avoid him facing the death penalty once he is found guilty. Let me know your thoughts. Obviously, this is open to a lot of interpretation, and as you know, I'm also a little bit out of it because I am on heavy painkillers for a broken shoulder, so I'm probably not as good at this as what I may usually be, and I'm perhaps missing a few important points here just because my brain's a little bit slow at the moment. Anyway, let's leave it at that. So, thanks for listening. If you're new to my channel, please subscribe. Also, please hit the like button. YouTube loves it when you hit the like button, and hopefully that'll get my videos out into the algorithm and help me to grow my channel. And leave a comment below. What are your thoughts on all these motions that are being filed? I'm really looking forward to hearing people's comments on this video. So thanks, and I will catch you in the next one.
Give a fuck about me, 'cause